If you have a 401k, an IRA, a pension, a TSP, or really any retirement account, there's one question you need to know the answer to. What happens to that money when I die? Now, you would be surprised how many people think they know the answer, and unfortunately, they're often wrong. In fact, one of the biggest surprises I see in my practice is when someone says, "Don't worry, it's all covered in my will." Sometimes it is, but very often it isn't. I once met a woman whose husband had passed away unexpectedly. She brought me his will and confidently said, "Everything comes to me." That's the way my husband set up his will. And then we started looking at his assets, including his retirement accounts. That's when we discovered he had never updated the beneficiary designation after his first marriage. Even though his will left everything to his current wife, the retirement account had a completely different beneficiary on file. Needless to say, that was not the outcome that anyone expected. I'm attorney Yanique Otto, and I'm a Florida estate planning attorney. Every week, I help Florida families protect what they've worked so hard to build, and retirement accounts are one of the most misunderstood parts of an estate plan. So let's clear up some of that confusion. The first thing I want you to understand is this. Retirement accounts are different from many of your other assets. Your home, your car, and many other assets may pass according to your estate plan and how they are titled. Retirement accounts, on the other hand, often pass according to something called a beneficiary designation. Now, what does that mean? When you opened your retirement account, you were probably asked to complete paperwork naming the person or people who should receive that account if you die. That document is incredibly important. In many cases, it controls who receives the money, even if your will says something different. Now, think about that for a minute. You could spend thousands of dollars preparing a beautifully drafted estate plan, carefully deciding who should inherit what, and if your beneficiary designation doesn't match your current wishes, your retirement account may go to someone or somewhere you don't intend. Now, that's why I tell every client that an estate plan isn't something you create once and forget about it. It's something you review as your life changes. Another client once asked me, Attorney Otto, I got divorced 5 years ago, but my will is updated. So that's everything I need to do, right? I changed my will. And the answer is simply maybe, but maybe not. One of the first things that I would want to know is whether the beneficiary designations on all of your retirement accounts have been updated too. Because here's the reality. People change jobs. They roll over old 401ks or 403bs if you work for a nonprofit. They open new IRAs. They remarry. They have children. Life changes. But beneficiary forms often stay exactly the way they were 20 years ago. Not because we don't want to change them, but because we just don't think about it. We don't remember. I've even had clients tell me they weren't sure who they named because it was so long ago. And that's not something you want your family discovering after you're gone. Here's another question I hear all the time. My spouse is my beneficiary. Doesn't that solve everything? Well, sometimes, but what if your spouse dies before you do? Have you named a contingent beneficiary? And if not, what happens to the funds then? These are the kinds of questions that people rarely think about until there's a tragedy. And that's exactly why planning ahead of time actually matters. I also get asked about naming children as beneficiaries for these accounts. And people will say, I want everything divided equally among my kids. And that's a wonderful goal, but let's take it one step further. How old are your children? Because naming a minor child directly as the beneficiary of a retirement account can create complications you may not have anticipated, and it makes things even worse than you planned. That's one of the reasons that I always encourage families to think beyond the simple question of who gets it and ask what's the best way for them to receive it. Sometimes those are two very different answers. Another question that people ask me, should I name my trust as the beneficiary instead of my children? That's another classic estate planning question. And just like many legal questions, the answer depends on your goals. For some families, naming a trust can provide additional protection and control. For others, naming individuals directly may be the better option. There isn't really a one answer that works for everyone, which is why personalized planning is so important. So if you have the type of family that, I call it simple estate planning, where you have two children and you want everything to go to them equally, then maybe you name those two children and then everything passes to them individually. But if you have a little bit more complex situation where you may not want it to go to them evenly, or you may have a child that you want things to be dispersed over time, right? You don't necessarily want them to get a lump sum right away. Then we may name the trust as the beneficiary. And then within the trust, we're going to specify how you want those disbursements to be made. Now, one mistake I see people make a lot of the times is assuming that all retirement accounts work exactly the same way. Well, they don't. Different types of accounts can have different rules, different tax consequences, and different planning opportunities. That's another reason why I encourage people not to rely solely on general advice that they read online, or even a video like this that you're just watching to gain general information. General information is helpful, but personalized advice is even better. Now, I also want to talk about something that doesn't get discussed enough. People spend decades building their retirement savings. They contribute every paycheck. They make sacrifices. They delay gratification. And then when it comes time to decide who should inherit those accounts, they spend about 30 seconds filling out a beneficiary form. That's backwards, if you ask me. The beneficiary designation deserves just as much attention as the investment decisions you've been making for the last 30 years. Because what if it's wrong? The consequences can be significant. So one of the best pieces of advice I can give you is this. Pull out your beneficiary designations and actually look at them. Not next year, not when you retire, this week. I want to say today, but I'm going to give you a little grace. This week, ask yourself a few simple questions. Is the person I've named still the person I want to receive this account? Are they still living? Am I still married to that person? Are they the one that I still think should inherit from me? Have I named a backup beneficiary if my first choice passes away before I do? Have there been any major life changes since I filled out the paperwork? You would simply be amazed how many people discover outdated information simply because nobody asked them those questions. I remember one time I was meeting with a client who had worked for 3 different employers, if I remember right, over the course of her career. And she had retirement accounts at each one. Plus, she had an IRA that she had opened on her own. And when I asked if all the beneficiary designations were correct, she just smiled and said, yeah, I'm pretty sure they are. I think so. And I said, I think so. That's not the answer you want when you're talking about your assets that you've spent your entire working life accumulating and building. So we made a list and we contacted each financial institution. We requested copies of the beneficiary forms, and sure enough, one account listed her late husband, another listed her sister, and a third reflected what she actually wanted today. She wasn't careless, she was just busy. And that's exactly what happens to so many people today. Life gets busy. Years go by. You assume everything is fine because you don't think about those accounts very often. Until one day your family has to. Another question I hear is, Attorney Otto, if I have a will and a trust, why do I still need to worry about beneficiary designations? Well, here's why. Because your estate plan and your beneficiary designations should work together, not compete with each other. Think of your estate plan like an orchestra. So every instrument has a role. Your will has a role, your trust has a role, your powers of attorney have a role, and your beneficiary designations have a role too. When they're all working together, your family has a much smoother experience. When they're not, confusion follows. Here's another mistake that I see. People sometimes name one child because they trust that child to do the right thing and divide the money equally among the siblings. Now, sometimes that works. I have seen cases where the one child then takes the money and distributes it equally. But sometimes it creates hurt feelings, it creates misunderstandings, and sometimes it even creates lawsuits. So if your goal is for all of your children to inherit equally, don't rely on verbal promises or just on one child to, give to the others. Put your wishes in writing and make sure your beneficiary designations reflect those wishes. Clarity is one of the greatest gifts you can give to your family. Now, let's just talk about one more thing: taxes. Retirement accounts often come with tax rules that don't apply to many other assets. That's one of the reasons I encourage people to coordinate their estate planning with both an estate planning attorney and a qualified tax professional or financial advisor. A decision that seems simple today could have tax consequences for your beneficiaries tomorrow. The goal isn't just to leave an inheritance, it's to leave it in the smartest way possible. So, what should you do today? First, make a list of every retirement account you own, not just the one from your current job. Include old 401ks, 403bs, IRAs, Roth IRAs, pensions, TSP accounts, and any other retirement assets you've accumulated over the years. Second, request copies of your beneficiary designations. Don't assume, actually request and verify. And third, review those designations after every major life event: a marriage, a divorce, the birth of a child or grandchild, a death in the family, retirement. Any major change is a good reason to make sure your plan still reflects your wishes. And finally, make sure your beneficiary designations coordinate with your overall estate plan. Your attorney should know who you've named. Your financial advisor should know your goals. Everything should work together. The bottom line is this: your retirement accounts may be some of the largest assets you ever own. Don't let a beneficiary form you filled out years ago determine your family's future by accident. Take a little time now to review your plan. It could save your loved ones confusion, conflict, delays, and potentially costly mistakes later on. Now, if this video helped you understand retirement accounts a little bit better, I'd love for you to like this video, subscribe to the channel, and share it with someone who's been saving for retirement. Chances are they'll learn something they didn't know today. And in my next video, we're going to answer another question I hear all the time: how much does probate actually cost in Florida? People are often surprised by the answer because the cost isn't just measured in dollars. It's also measured in time, stress, and sometimes family conflict. We'll break it down together. Until then, plan wisely, live confidently, and I'll see you next time.